Welcome back to the Law&Crime Network. I'm Bob Bianchi, and we have the honor and privilege to bring on our guest for the next couple of hours. It's Gary Gerstenfield from Maryland. He's a criminal defense attorney. Welcome to the show, Gary.
Good to be with you, Bob, and hello to your listeners and people watching on TV.
Yeah, I mean, Gary, listen, we just got to do a little spot on that old lady, plus 90 years old, at Dulles Airport. She's getting the pat down. We saw the video there. I know there's a lot of outrage about this. I think I'm going to have a perspective that's going to be a little different from more of the outraged people. But what are your thoughts? I mean, do you think that this was excessive, wrong, or should have been done differently?
The TSA workers are supposed to follow protocol, and they pick out a certain random number. They're supposed to do a more aggressive search. And unfortunately, this woman happened to be in a wheelchair, happened, I guess, fit that number. And so she was subjected to that additional scrutiny. It's 6 minutes of being patted down and looked at. You know, it is what it is. And it certainly, I guess, upset her family. But at the end of the day, she got on the plane. She wasn't delayed getting on the airplane. And I don't believe she was disrespected other than taking additional time.
Yeah, you know, and I think that when they're training TSA officers, just like when we would train police officers in the law enforcement community when I was prosecutor, you want them to exercise discretion, but there are certain areas, especially when they have the random hit, that they have to do it. They're not allowed to make exceptions for, oh, it's a baby or it's this person or that person. They're supposed to follow protocol. And what I found as prosecutor when I was dealing with law enforcement officers is that the more discretion that you're giving them, the more uncomfortable they are. They want to know exactly what they're supposed to do and follow that protocol. So I personally don't see anything about it. I don't think the TSA officers seemed over officious. They seemed to be gently handling her. I mean, the visual looks really bad. And yeah, you could say, well, what's a 90-year-old woman going to do? But I could tell you stories, Gary, I'm sure you know them as well, of people that were, and I'm not suggesting this woman was, but when law enforcement makes decisions like, oh, this is a nice old lady, or this is just a little baby in a baby carriage, things have been transported through the mechanism of those people for the very reason that people look at them without suspicion. Right.
You see them without seeing them. Well, there was a very unfortunate situation that happened at the Holocaust Museum, which you think the last place you would ever actually be subject to terrorism. But this old man came in. He was stiff because he had a gun wedged in, somehow hidden into his pants leg or something. And he actually was there to shoot and kill people, and he actually did. He shot two of the security guards at the Holocaust Museum. One of them was trying to help him, figuring that he probably was a survivor of the Holocaust. No idea that this guy had long-term anti-Semite and just a terrible human being. And it turned out that this guy was there to do wrong.
Right, yeah. So, I mean, I think they got a tough job. You're damned if you do, you're damned if you don't. But they've got certain protocols there, and they're very, I know the training, I know people that actually give that training, and there are no exceptions, period, end of story with respect to that. Obviously, they can go to a supervisor and they can ask, but I think that their actions were relatively reasonable. Although, you know, a lot of times we deal with this. So we recently had a case out of Wildwood, New Jersey, with cops punching a woman who was resisting arrest. And sometimes the video can just look really compelling, but the underlying facts, when you really get to them, will be more reasonable. But obviously, this did not look good for TSA, but I think it was appropriate. Hey, folks, we're listening to North Carolina versus the Wallace Bradsher case. We've been doing this for a couple of days. I agree with the people that are in our chat room here and all of our guests, great guests like Gary. This is really a fascinating case. And just to break it down real quick, in case you just joined us, these are two district attorneys from two separate counties that basically hired their wives to work with them. And I'm kind of interested, Gary, because we got a little time on our hands here, so we can kind of get into this a little bit. You know, when I was prosecutor, we weren't allowed to hire our family members. And apparently the AOC, the administrative officer of the courts down there in North Carolina, said to this guy Blitzer, who became a new district attorney, hey, you can't hire your wife. And Blitzer then calls Bradsher, who says, wait a minute, I thought that was okay. Your wife was out there open and notorious, working for you for a very long time, and nobody ever complained about it. Why am I getting this notification from the AOC that it's wrong? And then they meet later on in a pizzeria. and then make a decision. The infamous DA wife swap. Well, I'll tell you what, you hire my wife, I'll hire your wife, and ultimately this leads to an investigation, and that investigation reveals that while Bradsher's wife was working and earning her money, in fact, Blitzer's wife was working in the beginning, then stopped working, had no responsibilities, and was collecting a paycheck. Just on the face of it, folks, and Gary, let's get to you in a second. You got this DA now on trial as a defendant, which is a prosecutor's nightmare, and he's representing himself. What are your thoughts about this whole cockamamie scheme, as well as what is happening in the courtroom? And is Bradsher doing a good job defending himself when the old advice is he who represents himself has a fool for a client? What do you think, Gary?
I think that's an accurate thing. You know, I was asked to comment about this before, and you just cannot represent yourself very well. It's very difficult. Juries have an expectation that people are going to serve certain roles, and the lawyer has a job to do, and the defendant or person accused of the crime, he's got a job to do. And trying to combine those two, the optics really are weird, and most of the time it just doesn't work.
Yeah, something that I find, like, let's say you're a really good trial lawyer and you think you're the smartest guy or girl in the room, and you very well may be, but what happens is some very interesting nuanced points that I'm sure our viewers have picked up on, which is when he's cross-examining Blitzer, his old friend, who he was sitting in that pizzeria with concocting the scheme, they wind up in a dialogue with one another where, in essence, even though Bradsher's asking questions, and just so you folks know, the judge instructs the jury that questions are not evidence, answers to the questions are evidence. Nevertheless, he's basically going back and forth with Bradsher. It's almost like Bradsher's testifying.
Right, he's arguing with Mr. Blitzer, and they're arguing about who did what. And what's interesting is Blitzer keeps saying, yeah, maybe, I don't know. Yeah, okay, maybe that's how it was. All right. And every time he does that, it really, I think, ultimately hurts Bradsher's case, because he's picking up on subtlety, on little things that don't matter. Like, what? Oh, you had pepperoni on that pizza. No, I had cheese. Okay, yeah. Well, maybe it was. Who cares? And so they get caught up in the stuff that doesn't matter. And again, that beats back to your original thing, which is where it's very difficult to represent yourself, because as an attorney, you have a distance and objectivity. You know what the elements of a crime are, and you know what you're trying to do. And when you're the defendant, you feel like you're the victim, and you feel victimized because, after all, you're being prosecuted, you're being persecuted. And you want to argue about everything, and the little things suddenly become very important to you, and ultimately, A, becomes very boring to a jury, and B, it doesn't move their ball along very far.
Gary, I don't know if you had an opportunity to see the opening statement of Bradsher in the case, but I thought he actually did a really good job at one point, at least, where he was talking about the reasons he went into prosecutorial world and the things that he did and the amount of time and everything that they were putting into the cases and the wife working for him. I mean, do you think that the jury gets or sees or feels that Bradsher was actually trying to do the right thing and may have made a technical mistake?
Well, okay, so what are the major hurdles that Bradsher has to overcome? Well, first of all, he's got to overcome the fact that Mr. Blitzer's testifying against him. He's got to get over the fact that Mr. Blitzer's wife, Cindy, who worked for him, didn't actually work. I mean, it was a pay to play and didn't actually have to do anything when she was pursuing her nursing degree. In fact, he was providing tutoring, I think, for her through some of his subordinates, which sounds bizarre. But the bottom line is the co-defendant, or the person who has agreed to testify for a lighter sentence, a lighter deal, is the guy that was there in the restaurant when they did this wife swapping. And the bottom line is wife swapping. It's a problem.
Well, yes, it typically always turns out that way. Anyway, so we have on the stand right now in the North Carolina versus Wallace Bradsher case, the SBI agent, David Whitley. I think it's a really important testimony. We're going to go back to a clip of his testimony about how he was conducting that investigation. And on the other end of that, Gary, let's do some back and forth about whether we think it was helpful or harmful to the prosecution's case. Welcome back to the Law and Crime Network. You're listening to North Carolina versus Wallace Bradsher. This is the examination of the SBI agent David Whitley, who actually investigated the case and gave his findings over. You were listening to Gary. We are listening to this testimony. I think that one of the most compelling things that is going to be against Bradsher in this case is the cover-up. And if you're doing nothing wrong, I'm just going back to my own experience as the prosecutor. I had complete discretion to determine how my employees were working, when they were working, what they were doing. I mean, we had some employees that were there, I mean, no disrespect, they were sitting there and they may have been at their desk technically from 8:30 to 4:30, but not even getting a lot of work done. And I had other employees who work 16, 18 hours a day. It's about the quality of the work that's going in, not necessarily whether you're inside the office. I think he could have had a defense there, but I think that this cover-up is a problem because it goes to consciousness of guilt. What are your thoughts?
Absolutely. Consciousness of guilt is always a problem. The biggest problem, though, he's going to have is the fact that again, he entered into a sort of a Cladstein meeting with Greg Blitzer. I mean, that's Blitzer's take on the case. Blitzer's take on the case was, this is something we were going to keep on the down low. And, you know, that's the guy that he's in this conspiracy with. So what constitutes fraud is often from the eyes of the beholder. But if your own co-participant says, yeah, we did wrong, you're kind of dead in the water. Yeah,
but you know, you also, the cross-examination has brought out that he had great incentive, that is Blitzer, to cooperate with law enforcement, up to and including the fact that although he pled guilty, he may wind up getting this prayer for judgment in this wink and nod agreement that went on behind the scenes. You know how that goes, where, you know, he had all the incentive in the world, not to mention the fact that his wife didn't get charged. And some of the things that I'd be bringing out as Bradsher, and this is, well, if you thought it was wrong, why did you do it? You're a lawyer. You were an elected district attorney. You were a criminal defense lawyer. And I was doing it open and notorious. And in fact, Cindy Blitzer was working for him at a particular point in time, and then that work ceased, and we just don't seem to understand why. I mean, that's that kind of reasonable doubt piece in my mind, except for all this stuff about these records, Gary.
When you're hiding or concealing something after the fact, it doesn't look good. At the end of the day, the jury's going to say, gee, would he have been able to do this, or would he have done this if he wasn't getting a benefit, if his wife wasn't getting hired? In other words, what was in it for him? And it always seems to me that juries sometimes will take what, you know, you try to complicate a case in your defense. You try to say, oh, this issue here, you got to do this burden, that burden. You try to make it as convoluted as possible. Juries sometimes take that back and they say, well, okay, what happened here? Well, they met in a restaurant, they worked out a deal, they hired each other's wives. That's wrong, that's illegal, that's a crime. Convicted. And I think that's the biggest problem he's going to have. Yeah, the problem, though, is that really technically, while it may have been a little swampy, I like to use since it's such a popular word, it wasn't necessarily illegal. And in fact, they changed the policy afterwards in order to address this situation. So while it may not look great in the public opinion, it doesn't necessarily mean it's a crime. Gary, we got about a minute left, and I want to ask your question on this because I think it's really important. The difference between an elected district attorney, like you have here, versus somebody like in New Jersey where you're appointed by the governor with the consent of the Senate. I've always preferred the appointment process because after that, I'm not worried about the constituency. I'm not worried about how public perception looks, you know, to that extent. They don't decide whether I keep my job or don't. Do you think that maybe he was trying to cover this up, not necessarily because it was a crime, but because he was worried about his constituents and the vote? Well, you're trying to get into the mind of a particular defendant. It's hard to say what exactly motivates people to cover something up. And in terms of whether someone should be elected or appointed, you know, there are benefits and certainly negatives each way. I think, though, ultimately in this case, I don't think it matters. I think the bottom line is that there was a Cladstein meeting at a pizza restaurant, and there was a deal to hire each other's wives, and there's argument that Cindy wasn't actually doing work, which again is the wife of Mr. Blitzer, who was working for Mr. Bradsher. I think at the end of the day, I think that's going to be his biggest challenge.
Okay, great. Listen, guys, I think it's really important to continue to do this. I love doing this. I think it's a great technique. We're listening to Detective Whitley, who is the agent for the case that investigated it. But let's now go back to the opening statements and take a look at how this evidence, when it was being presented to the jury, or in the evidence in the opening statements, and whether or not Whitley is helping to assist or not assist with regard to either side of the case. We'll be back on the other end of the opening. Welcome back to the Law&Crime Network. It is the only network that's live gavel-to-gavel coverage. Gotta love it. The hosts, the guests are amazing with great experience to give you insights into these trials. And this is the trial of North Carolina versus Wallace Bradsher. He is a former district attorney who is now on trial for his life as a defendant, and he's representing himself. And what the prosecutor in this case that's prosecuting the former district attorney is saying is that he had an agreement with this guy, Blitzer, who was another district attorney, and that they concocted a scheme for the DA wife swap, that is to get around the AOC rules, the administrative office of the courts, that each one would hire the other one's wife because they weren't allowed to have their own wives working for them. But Gary, we're just talking about the fact that Bradsher had his wife working for him for years, open and notorious, and no one was saying a word about it. I mean, would you be making a big deal if you were Bradsher to say, why would I be doing something so obvious that I thought was wrong? I just made a mistake.
Well, the problem here is that when you listen to the opening statement, I think the prosecutor gets it right, and that is, would Bradsher have hired Cindy but for the fact that his wife was being hired by the other DA, Craig Blitzer? In other words, the pay to play is I'll hire your wife in exchange for, and in the end, it turns out Cindy gets hired by Mr. Bradsher and apparently isn't doing a whole lot of work. Why is she not being fired, or why she's not being criticized for that? Because he already has a benefit, which is that his wife is working and he's getting compensated for that. So it's affecting the performance expectations on the part of Cindy by Mr. Bradsher. And the fact of the matter is that this whole meeting was done somewhat in secrecy.
Well, yeah, but then the thing that's, and we'll play point counterpoint here. I'm going to be more, I guess we're going to reverse roles here. You'll be the prosecutor, I'll be the defense lawyer here. The thing that I'm thinking of is that if this was this nefarious agreement for pay for play and each one wasn't going to do work, what we learned, though, is when the agreement was entered into, in fact, Cindy Blitzer did do work for Bradsher. She was working on a big case and then, unknown to us for some reason, was taken off that case. So when the agreement first started, they both wives were, in fact, working. In the law, when we're talking about fraud or obtaining something by false pretenses, it starts really when the agreement is entered into, or in your mind, does it transform at some point in time? Maybe it wasn't. See, I'm arguing it wasn't a crime when they first agreed to this because, in fact, both women were working. Does it become a crime later on when Cindy Blitzer decides that she's going to go to nursing school because she's got nothing to do in Bradsher's office?
That's a very good point. Look, this case would be a whole lot easier for Mr. Bradsher if Mr. Blitzer, he's the one who has agreed to cooperate and testify against him. If the two of them are holding hands and said, we did nothing wrong, and you know, each of us hired each other's wives because, you know, a mutual respect for each other, and this crazy thing with the AOC saying that, you know, we can't hire our wives, so we just agreed to hire each other's wives, and we did nothing wrong, and we were open and upfront about it. That'd be a much easier defense to make. But that's not the case that you have here, and that's why, you know, as a defense attorney, I always look at the prosecutor's case from, okay, what's the strongest points they have, and what are my strongest points? The strongest point that the prosecutor has in this case is that one of these guys who's cooperating now is testifying against is now testifying as a prosecutor witness. That's going to be a major problem. It is a major problem.
You know, we're doing here the trial on the gavel-to-gavel coverage network at Law&Crime on this Wallace Bradsher case, and this is the DA wife swap case. But now we are doing the guest host, defense lawyer, prosecutor, lawyer swap here, because I'll make another argument to you, Gary, and you're making great points, of course. But like, if at a certain point in time, when Cindy Blitzer is no longer has any responsibilities, and Bradsher says you can go to nursing school, I'll catch up with you later about work. And Bradsher's wife is working and she's doing her job. I mean, if this was some concocted conspiracy, wouldn't Bradsher be saying to Blitzer, "Hey, dude, what's up, man? I'm letting your girl go, your wife go to nursing school, and she's not doing any work for me. And you got my wife over there working." If this were that kind of scheme, wouldn't you expect to see something like that?
That's a good point. I mean, it's certainly a strong argument to make. The question is that going to carry the day with the jury? This is Raleigh County now, so this is, these are people of the earth, and they're looking at this thing and they're seeing, two lawyers who got it together and made a deal and they're hiding each other's wives. That is a really tough set of optics to overcome. I agree with what you're saying. Maybe there wasn't fraud in the beginning, and maybe Cindy stopped working so hard, and maybe she should have been fired, and maybe out of guilt or whatever he didn't fire her, or maybe he felt that she would return back to work, and maybe she would eventually become a real asset to the firm or to the office. I mean, all those things are true, but again, the optics are really going to be tough, particularly for this type of a jury.
Well, you said maybe a number of times, and that maybe to me is where reasonable doubt can come in. If it weren't for, in my mind, some of this cover-up and obstruction for which he's charged with. And what I liked about what you said most was, Gary, without any doubt in my mind, is when you said, you're right, you're making a good point. That was actually awesome that you said that. I'm definitely kidding. But we got a little lawyer swap going on here, and we have the DA swap case here with Bradsher, and right now we have the testimony that we've been listening to of the investigator of this case. There is a lot of maybes, but remember, the state's got to prove it to 12 beyond a reasonable doubt, and that burden is always difficult, especially in a complex factual case, in a complex legal case. But I agree with Gary that there's just such an ugliness to it and a stickiness to it. Let's agree. I mean, there's no doubt it's unethical. You're trying to do through the back door what you can't do through the front door. Jurors just may not like it, and we know that jurors, and all of us for that matter, judge things based on emotional reactions to certain things based on what they're hearing. So fascinating case. But again, let's go back now to the opening statement, and let's, after on the other end of that, go back and ask a couple of more questions. Who's winning this case, guys? Go on the Law&Crime Network. Let's see what you got to say in the chat room. Are you convinced? Is the prosecution so far proving this case beyond a reasonable doubt? Or are the facts and the law, as we like to say, a little too squirrely for you, if you were a juror, to find the person guilty? We'll come back on the other end of the openings. Welcome back to the Law&Crime Network. We were there listening to the opening statement of former district attorney, now defendant, fighting for his life, Mr. Bradsher. We're going to get back to that in all the openings, as we're going to analyze them a little further down the road. But I still have Gary Gerstenfield with me, Maryland criminal defense attorney. Welcome back, Gary.
Good.
Yep, we were talking before about this whole concept, and our producers are doing a great job putting these segments in here about how he's talking about how he did this for a laudable purpose, and he was trying to bring his team in there, and they were working really hard. Effective or not effective?
It's effective. It's good. He's a good trial attorney. He certainly knows how to control the room, and certainly, a big guy can really fill up a room in more than just size. He's an imposing figure. He's a good speaker. He's able to convey honesty and integrity. I think he's doing a great job.
Yeah, it's certainly an odd thing to see a former district attorney as a defendant and actually defending himself. I don't know of a case that is ever like that before. It'd be an interesting research project, but if there was one, it's been a really, really long time. Hey, folks, listen, we're going to get back to that trial, but we got some new top crime stories for you. We're going to shoot to that, and then on the other end, we're going to come back with more Law and Crime Network, the only live trial network with gavel-to-gavel coverage and great guests like Gary. Out to the Law and Crime Network, and those are some amazing top crime stories. But Gary, this Devin Patrick Kelly, 26 years old, the First Baptist Church in Sutherland Springs, Texas. That was one of our top crime stories. And now the family is suing for $50 million, suing the federal government. Brian Holcomb and the family lost 8 other family members, you know, in that terrifically horrible shooting in a place of worship. We're seeing more and more of this carnage as we go through, you know, our lives, unfortunately. But Gary, I'm curious, the U.S. Air Force failed to, in violation, it is alleged, of their rules and procedures and the law, notify NCIC, which is the criminal case history lookup that law enforcement and firearms dealers would use to see if somebody had a criminal conviction, for a court martial that he had where his wife and stepson were the victims of an assault. He was discharged from the military, and he was supposed to have that recorded. And the Air Force has essentially admitted that they did not do the right thing, and the plaintiff in the case, which is now this family, is saying that there was a, quote, systemic and long-standing failure to comply with the law, internal policies, regulations, and guidelines. Gary, what do you think? Good case, not a good case?
Well, first of all, you know, our hearts go out to the family, and certainly this is a terrible case, but it's not an uncommon situation where, for whatever reason, convictions are not properly marked in one computer isn't talking to another computer. In this case, the Air Force was not actively notifying civilian authorities about convictions in their military court system, and that's certainly something that needs to be fixed, and I think probably is being addressed. That being said, it does not create civil liability for a lot of reasons, but I think the most basic one is that it would be speculative that had that information been known, he would not have been able to obtain a gun. Not being able to obtain a gun, he would not have been able to commit this crime. There's a lot of speculation there that would be very difficult for a plaintiff to be able to make.
Yeah, Gary, you bring up a great point. Listen, obviously a terrible thing. And I think clearly, as terms of what the Air Force didn't do, because there's a law, rule, or regulation under federal 1983, 42 U.S.C. 1983 litigation, you have to show a custom practice or policy of deliberate indifference. Those are the actual words. I was a civil rights litigator for many years. And so you're right that it was negligent what they did, but does it prove a custom practice or policy that causally related to this injury? And the big question would be, how do we know he couldn't have got his hands on some other gun? And that's basically where you're saying this case is probably going to fall apart for the plaintiff.
Yeah, it's unfortunate, and certainly I understand why the family is, you know, grabbing onto this part about, well, this wouldn't have happened but for. But unfortunately, when people mean to do bad things, they'll find a way. And not being able to buy a gun at the store in and of itself probably would not have stopped this gunman from doing what he did.
Well, to be very, and you're bringing up a great legal point, and it really comes down to facts like everything else. The law is one thing, the facts are another. It'd be very, very interesting to see what the proximity was from him getting that assault firearm unlawfully to the actual incident itself. In other words, if maybe that had popped up on the NCIC computer and said he's not authorized to have that weapon, he may have, whatever psychiatric issue he was going through, been able to get help as opposed to go in there and actually cause this carnage. I think that that's going to be an important set of facts, Gary, don't you? I do. And it raises a second issue, of course, which is whenever you have one of these cases that, you know, $50 million, and you know, that's the beginning of the lawsuit. For the plaintiff, surviving what's called summary judgment is really the challenge. Summary judgment is where the defendant, in this case the government, the Air Force, would say, we're not liable because it's speculative, because of this, that, and the other, or you can't show a pattern of neglect that rises the level that this case can actually see ever see a jury.
And I think ultimately, I think this case will probably fail for the plaintiff at the summary judgment status or state.
I have a little bit of a different twist on it. I don't agree. I mean, I don't disagree with your analysis of the law, but we also know that there's another thing about law. Law is one thing. Common sense and the practical, tactical application of law is another. And what they've got here, as I like to say, is a big matzo ball of publicity problems, the federal government. And there is going to be some bean counter that is there. Trust me, I've dealt with it in civil cases when I was a county prosecutor, where they're going to say, well, it costs X amount of dollars to litigate, the publicity is really bad, the family was really injured, and I'm certain they're going to come up with a settlement number rather than muscle through it. And if they could resolve this case, they'd rather just get rid of it and the pretrial publicity. Don't you think that's going to come into play?
Well, what the argument is that benign incompetence is sort of the point here. The government didn't intentionally fail to provide this information. It's an affirmative duty. They had to notify, or they were supposed to notify NCIC. They didn't do it. So let's call that negligence, and we'll call it benign negligence. I think it was intentional. And the problem is that if they pay out money in this case or opening the floodgates, particularly a case that's being well followed by the press, they're opening the floodgates for other cases involving basically benign incompetence on the part of the government. And there's certainly lots of those cases, unfortunately.
You know, it's funny, we got 30 seconds left before we go into the next segment of the show, but I have found that there are some government entities that just decide to do the quick, get rid of it saves money, and not get the publicity, and then there are others that will fight cases that they shouldn't be fighting all the way through trial, where it's almost a no-brainer they're going to lose. It's very disparate about how government entities decide to resolve these cases, and as you know, there's been a big push about how many times it's not transparent. The settlements are sealed, but now they're becoming more open to the public.
In this situation, though, the cases with the Air Force, the federal government, they're not really that concerned about their image. This is not an attack against specific members of the Air Force. This was a pencil pusher mistake that was made by not notifying NCIC. It's a kind of case that, unfortunately, the fact pattern of this case happens over and over and over again, where someone was supposed to do something and didn't do it. I call that benign negligence. And that's just not the kind of thing that's sexy, and that's not the kind of thing that I see that the government's going to give up on. I think they're going to, and the value of the case certainly goes up if the plaintiff survives summary judgment, and that's the jumping on, jumping off part. Can they survive summary judgment? If they survive summary judgment, now the government has concerns that this case may actually find its way in front of a jury, and there maybe settlement starts making more sense. Right.
Well, the plaintiff has alleged in this case that it just wasn't an isolated incident, because that's virtually impossible to prove under the federal law. They're saying it was systemic and continuing. We don't know. We'll see the facts, and like you said, Gary, you're right. It's going to come down to that summary judgment motion. Appreciate your response to that. But listen, folks, we are here at the Wallace Bradsher case, and we've been having some great analysis by our great guest, Gary, here out of Maryland, criminal defense attorney, about the case. And we're going to go back to Bradsher, the defendant, former district attorney, opening statement on the old wife swap case. We're at a place right now where he's telling the jury, woe is me. I was just there, a poor public servant trying to make our community safer, trying to do the right thing, taking a substantial pay cut, and I was just bringing my team of people from private practice to make government and the district attorney's office run better. Let's go back to those opening statements. Welcome back to the Law&Crime Network. We are at North Carolina versus Wallace Bradsher. You are looking at a former district attorney standing in front of 12, not prosecuting a case or trying to say that somebody committed a crime. He's telling you all about the things, why he wanted to become a prosecutor. No, you're seeing him as a defense attorney defending himself, fighting for his life on some really serious charges that include, up to and including, felony obtaining property by false pretenses, aiding and abetting conspiracy and obstruction for this wife swap case. This is where he and another district attorney, Craig Blitzer, came up with an agreement and a pizza pile to hire each other's wives, and ultimately it unraveled based on the investigation. As you see there on your screen there, Mr. Bradsher had to leave his job, and now he is called Defendant Bradsher. So fascinating case here, folks. I love the commentary that's going on in the chat room here on the Law and Crime Network. Only here can you get gavel-to-gavel coverage with the great guests that we have. And I have to say goodbye to our former guest. He had to take off. His time period was done. But we are going to go back to the opening statements and discuss that with you on the other end. Thank you. You are back at the Law and Crime Network. We're listening to the opening statement that the prosecutor gives, because it is always imperative to go back to the openings and closings and see how the evidence is fitting in. Gary, I just want to, based on what we just heard there, these clips are really amazing because they're going right into the topics of discussion that we talked about. And one of our chatters, 50 Flower, came up with this sentiment, and I think it's really important when we discuss the concept of jury nullification. They're all liars. Give him the deal that Blitzer got is what that reference was to. And Diana 421 says, I'd have a hard time convicting Bradsher, considering Cindy knowingly did what she did and got rewarded for it by becoming a nurse, yet has not been punished. These two comments by these two people in our chat room converge in my mind into something that I think is very powerful. Can you explain jury nullification to our audience? And do you think there's that sentimentality there that, wait a minute, we may push the button on this guy and he may go to jail, and this other guy who pled guilty may not even have any criminal consequences, and Cindy Bradsher, who was involved in all this, his wife, didn't even get charged?
Jury nullification can best be described or explained by the O.J. Simpson, the first trial, where the defense was able to put the LAPD on trial, and the jury, looking at that particular case with O.J. Simpson and looking at a historical point where the LAPD had, over the years, perhaps decades, built cases against African Americans based on lies, based on false information, ultimately false evidence. That resulted in the jury finding O.J. Simpson not guilty. And most commentators say that that's an example of the jury facing what really was a mountain of evidence and refusing to convict. That's an example of jury nullification. Why is that not a good argument, or why won't that happen in this case? Simply because somebody was not punished, or somebody did something bad and didn't get punished. You know, that's sort of like a kid's thing where, you know, that's not fair that I didn't get what, you know, my brother got. That's not going to work in terms of being found not guilty. I mean, guilt or not guilt is based on what the evidence is. And then ultimately what the sentence is, that's a separate issue, how much punishment is appropriate. But that's not the issue that's before the jury, what appropriate punishment should be. The question here is whether or not Mr. Bradsher committed a crime when he hired Cindy in exchange for his wife Pam being hired by Craig Blitzer. That's the case. And those optics, I keep using the word optics, those facts are the challenge that he has. And the other point that you point out, of course, is sort of this consciousness of guilt by hiding evidence later.
I guess maybe it's the prosecutor in me that we always worry that there'll be one juror out of 12 that may nullify. I've seen it happen on cases, thankfully not my own, where they just feel that they're just uncomfortable with that conviction. And I'll tell you where I would go if I were Bradsher really hard as a defense lawyer, is the fact that I'm on trial when my wife was working. I'm on trial when my wife was working, and the state even admits that. And yet this guy isn't on trial, cooperates with them, knew full well his wife wasn't working, and now is coming in here to testify against me. I just think that it could put pause in the minds of some jurors. But listen, Gary, we appreciate certainly your opinion's excellent. We are in the opening statements. I think this is a great, worthy conversation to have right now. So let's go back to the prosecutor's opening statement, and I'll be discussing it with Gary on the other end.